Good afternoon and welcome to another edition of Ask Judge Carol Live, where I break down the law for you and help you to understand your everyday legal problems. Because we do have those problems almost every day in some form or another. Today's topic is when an administrator dies before the job is done. And I got an inquiry from someone in Guyana with a pretty complicated set of facts that I'm going to run through today. And hopefully you will see from that, you'll get some pointers that you can take away, and that will be helpful. So I'd like to say thanks to Candace from Guyana for submitting this question. So what happens when the person appointed to distribute an estate dies before the job is done? So this is a real case I have in front of me now. A mother passed away without a will in 2021. Her name was Winifred, and she left 10 children, and she had one child that predeceased her. So 10 surviving children. By agreement between the 10 of them, they agreed for the eldest son, Carl, to take out administration from the estate under the Guyanese Deceased Persons Estates Act. But before he was able to complete administration, he was murdered. So unfortunate for him and for the family. So this is a very tragic circumstance. And now the family was left with, okay, what do they do? And they're wondering, his siblings are trying to get things sorted. And in the meantime, the eldest son, his name was Carl. Not sure if I said that already. His children are claiming that they now are beneficiaries. Since he was the administrator, they have been asserting that they are entitled to the estate because they said their father left a will and he left his property to them. So as I said, Winifred died in 2021 without a will, so as an intestate. She left behind a fair amount of property, which is no doubt the reason why there is so much strife in the family. She left behind about 5¼ acres of registered land, some 10 acres of land on lease from the government, 2 houses, 1 shop, some crash crop, and a farm, all located in the Mazaruna River region, Region 7 in Guyana. So, and as I said, by agreement with the siblings, it was agreed that he would apply for administration. So there were some steps that had to be followed, which it looks like Carl had begun doing the right thing. So under Guyanese law, I took a look at this, and you have to register with, there's a particular department, I'm not remembering the name of it now, that you register with before you go ahead into the probate department and file for administration in that section. So Carl did things like he paid the rental and inspection fees in relation to the government leased land. He notified the other beneficiaries that he was taking these steps, and the surviving children agreed that they would pay the outgoings and rental for the lease as required by local law. So things were in motion and going, basically, you could say, in the right direction. And like I said, unfortunately, before Carl was able to complete the administration process, actually before he was able to formally file with the deceased persons, under the Deceased Persons Administration Act, he died under unfortunate circumstances. So the two children are complaining that, sorry, not the two children. So Carl's children, which would be Winifred's grandchildren, have been asserting ownership and rights to the entire estate. However, my instructions and my information is that these two children really visit the property unless there is a family gathering. They have no structure, they've not built anything on the property. So they're asserting a right through their father, but they don't have any connection to the land. That's what I'm understanding from this. Whereas the other surviving beneficiaries, Carl's brothers and sisters, have been living on this property for decades. And I already mentioned that they've been paying some of the lease, they've been paying the lease payments to the government under it. So they have actually, you can say they've physical occupation. There's evidence of them having physical occupation. They have been carrying out acts of ownership in relation to their own shares based on what they expect and are entitled to inherit under Winifred's estate. But it looks like there's a lot of contention. Oh, let me just say thank you to those of you who are joining live. It's good to see you. And if you have any questions for me, please, by all means, drop them in the chat. So yeah, there's a lot of contention from the grandchildren, between the grandchildren and the children. So they would be like nieces of the Carl's siblings, obviously. And things like going in to conduct a survey of the property, that would be very aggravating. You don't live there and you don't come there, but all of a sudden someone shows up on the property with talking about they're going to do a survey. That would definitely cause aggravation. And then there's also some information coming to me that one of Carl's daughters has an intimate relationship with an officer at a GLSC office, and that person has been privy to or been giving the nieces confidential information. Now, with those kinds of allegations, you have to be careful, because obviously someone working in a government office as a public servant, they would be under strict confidentiality rules. And also, you have to be careful not to be saying slanderous things about someone without evidence and without being prepared really to back it up. So my position in relation to something like that is, unless you plan to take action in respect of it, that's really a distraction that is keeping you from moving forward with what you need to do, which is what I'm about to get into now. So it is annoying. And I know people have this thing, well, she's talking to this person, they're talking to that person, and saying that something underhand is going on. Those, as I say, are serious allegations to make against a public servant, and you should be prepared to back them up and take the necessary action, because, if you have evidence of it, that someone is acting illegally and in breach of confidence, then I say, challenge them on it and call them out on it. Otherwise, that kind of action, you're enabling it and allowing it to continue. So there is something that you can do. The person must have a supervisor. They have an office that they work in. There's also the risk that if they're doing it with you, other persons, other families, the same thing is happening to them. And it's this cycle of inappropriate and irregular behavior that is being allowed to continue. So simply crying to someone, to me or someone else, to say, well, they're in a relationship with so-and-so, that's how they're getting to be able to subvert and twist the ends of justice. Well, if you don't say anything about it, then you're allowing that to happen. That's what my position is on that. So don't just whine and complain, but actually do something. So, and that brings me to the next point that I have in my notes. What should the family do? Now, some things that were suggested to the family were filing an emergency high court injunction to restrain the two children and their associates from entering the land and conducting any survey, and suing for damages or missing assets. Well, I mean, certainly that is something that can be done, but you have to, of course, filing an injunction is, it's going to be a considerable expense in terms of legal fees. And and suing for damages, you're going to have to bring together the evidence to show what damages have been suffered. And there's a fundamental principle of law that I think applies across the Commonwealth, Caribbean, and most jurisdictions, which is that you should take whatever steps you can take to help yourself. So going to court is one of those steps, but it is not the only step, and it need not necessarily be the first step. So the other suggestion that has been made to Candace and the family is that to take steps to protect any unauthorized transfer or cancellation at the GLSC office. I imagine that's the Guyanese Land Surveys office or something. And at the Deeds and Commercial Registry. So it seems like this would take the form of registering some kind of charge, issuing a notice, maybe some kind of public notice to these two grandchildren, issuing a cease and desist order to stop any transaction on the estate property while administration is being processed. So yes, that is something that you can also do in terms of preventative measures. But I prefer a more kind of proactive approach. And really, it's the first and best approach in these circumstances that I advise. So when a loved one has passed, when there's a question of administering an estate, while you can apply for a high court injunction and register a caveat or file some document with the Deeds and Commercial Registry, the best and first course of action is to actually apply for administration yourself as the now surviving family members. So the question that was submitted to me had some legal jargon in it, something called administration de bonis non, which means goods not administered. Now, just to explain that and also clarify, it does not appear that Carl had actually filed the application, submitted it to the court in Guyana. So he was the agreed and intended administrator, but he never actually got to that point. He had taken some preliminary steps to secure the estate, but that particular step he did not get to take. Now, if he had been appointed by the court, then his two daughters, who would be Winifred's granddaughter, would have a right to apply on the basis that he was appointed. And so as their heirs, as Carl's heirs, they could apply for administration in Winifred's estate in his behalf, since he would have been legally appointed. But since he never got legally appointed, they don't have any claim, and certainly not a better claim than the other brothers and sisters. So the remaining 9 siblings should agree and appoint one or two of you to now apply to the Guyanese court for a grant of administration. And it wouldn't be de bonis non, meaning for goods unadministered, because there has been actually no administration for Winifred's estate. So it would just be a regular application for administration. Okay. Again, my qualification on that is this is assuming that Carl never actually got a grant in his own name. So if he did not, then the next oldest or the next two oldest, but it doesn't have to even be the oldest. Once the 9 of you agree who should apply, then that's what you should go ahead and do. Apply for a grant of administration. And then when those siblings, when the next ones have been appointed, then you can now take those other steps. So we have, after Carl, there's Clyde, Jacqueline, Evelyn, Lawrence, Simon, Marlene, Martin, Anderson, and Clinton. So Clyde and Jacqueline, for example, could apply jointly for administration to your mom, Winifred's estate. And then once you have that grant, now you can sue, because without it, you can't bring a high court injunction. You have no legal standing in respect of the estate unless you all join in, and the courts aren't really they're going to frown on that. They're going to say, get someone, that's what they'll tell you, is to get someone appointed. So that's why I say that your first step is to formally apply for letters of administration, and then those other things can follow after that. Okay. And so the key takeaway from today's question and today's scenario, the executor or the administrator in this case has the responsibility to vest the title in the beneficiaries. So that land that we talked about, the leased land, the registered land, the farm and the shop and the houses and so on, they can be deeded out, but the administrator has to be appointed, and then they can do the deed for that. And in relation to Carl's children, they don't have any claim, except to inherit from his share, his 1/10 share, since he was alive at the time his mother passed. Okay, so I hope that clarifies things for you. Remember, my goal is to make the law simple and easy to understand. If you have a legal issue that is causing you to feel stressed or overwhelmed, or causing issues and strife in your family, why not book a private consultation with me so that you can have less stress and more peace by gaining an understanding of your options, and let's map out a way forward. Simply email me at info@judgecarol.net or send me a WhatsApp message at 242-451-4855 and ask to book your session with me, Judge Carol. Thanks again, and I hope you will tune in for another session of Ask Judge Carol.